Thank you so much for joining us this evening. My name is Georgia Haddad, and I'm a senior manager on our public policy and stakeholder engagement team at the Partnership for Public Service. For those of you who are not familiar with the partnership, we are a nonpartisan nonprofit working to build a better government and a stronger democracy. And we do that through policy advocacy, leadership development, workforce programming, and convening leaders across organizations and sectors. Another thing that we do is offer support to the federal workforce by sharing things like resources, providing plain language explainers, and amplifying the stories of the incredible work that federal employees do for our country every single day. Assuming the topic of this evening's webinar, I can guess that many of you are or have been public servants, so thank you very much for your service. Before we dig into today's session, I do just want to share a few notes, some housekeeping items. Throughout the webinar, please feel free to submit a question through the Q&A function. You should all have access to that, and we will do our best to answer what we can. Now, given the complexity and nuances of the topics that we discuss, we may not be able to answer everything that you have to ask today, but we're really going to do our best to try and answer as many as we can. And then we also continue to have these FedSupport webinars on a regular basis. And so we will certainly dig into future topics, and maybe some of the things that you want to answer will be answered elsewhere. So please do take the poll at the end if you have some suggestions about things that maybe weren't answered today that you'd like us to answer in the future, and always feel free to stay in touch with us through our FedSupport Hub. Of course, if you miss anything or want to revisit parts of today's session, you can view this conversation and other past webinars on the FedSupport YouTube channel and the FedSupport Hub itself, and we'll make sure to link both of those in the chat today so that you can have them saved. Before kicking things off, a quick disclaimer that the content provided during this session is for informational purposes only and is not personalized legal advice. The information will be general and provide an overview of processes and considerations, as well as offer inroads to potentially helpful resources beyond what's shared here. What you'll hear today is not intended to provide any legal guidance. If you do require legal advice, please consult with a qualified attorney who can assist you based on your unique circumstances. So let's get started with our discussion. And this evening, we are very, very lucky to have two former MSPB leaders with us who will be able to provide some helpful background on how the MSPB functions, the appeals process, and individual rights, as well as implications of legal actions. Please welcome me in joining, please join me in welcoming, Judge Richard Vitaris, retired administrative judge of the U.S. Merit Systems Protection Board and current president of the Georgia Federation of NARF, otherwise known as the National Active and Retired Federal Employees Association, and Raymond Limon, former board member of the U.S. Merit Systems Protection Board and founder of Merit Service Advocates, LLC, which provides pro bono strategic counsel and advocacy to protect an independent, merit-based civil service. With that said, and thank you again, both of you, for joining us this evening, I will pass things off to Judge Vitaris, who will get us started. Thanks again for joining us.
Thank you, and we can move to the next slide. I'm going to be giving you an overview of the MSPB, and we're going to be moving very briskly through the slides. In deciding what to discuss in the slides, we decided to give a comprehensive view. And even though we won't have time to discuss every aspect of what's in the slides in any kind of detail, I will be handling the overview because as an administrative judge for 28 years, I handled the appeals brought by federal employees for the most part. And I will discuss the process of filing a board appeal, what the board does, how it compares to the court system, just to give you a feel for the MSPB. Then Ray, who was a board member, will talk about the legal developments in recent days and the last year under the Trump administration and where things are going in terms of the litigation that is going on, challenging many of the agency actions that the administration has taken. Essentially, the board's mission, as you can tell by its name, is to protect the merit systems. The merit system is the opposite of the spoils system, where the winner enjoys the spoils from an election. And the purpose of the merit system is to make sure that federal employees are hired and fired based on merit and not by their political party, not by which policy positions they believe in, and to ensure that when someone is disciplined or if it's taken for legitimate management reasons and not based on partisan political considerations or unlawful considerations such as discrimination or retaliation. Next slide, please. Back one. The administrative judges adjudicate the appeals, and that's what I did. The board members function like an appellate court. I say like an appellate court because the board is an administrative agency that's part of the executive branch, not part of the judicial branch under Article 3. So Ray was one of the presidentially appointed board members who, among other things, reviewed the decisions from the administrative judges. Next slide, please. What can be brought to the appeal? Well, removals when federal employees are fired, demoted, suspensions, layoffs such as furloughs, and reductions in force. We also hear retirement disputes, but we're not going to talk about that in any respect today. Next slide, please. Federal employees under this system, under Title V, once they have completed their probationary period, have certain rights. In particular, the right to due process, which means notice and an opportunity to be heard. And Title V gives additional procedural protections, such as a notice period. Normally, an employee is given 30 days advance written notice before they can be disciplined. The right to a hearing. The right to have an official record developed of that hearing. The right to present and see the evidence brought against you. The agency needs to produce evidence. The employees can see that evidence, question that evidence, call witnesses, cross-examine witnesses, and present their own evidence in their defense. There's a right to representation, both an attorney and non-attorney representatives. You can also represent yourself. As an AJ, I would say about 30 or 40% of my cases were what we call pro se litigants. That is, an employee who's representing themselves. Many had attorneys, but you can also have non-attorney representatives, often union representatives if you were in a bargaining unit. But you don't need to be in a bargaining unit to have a non-attorney representative. You can have anyone you want represent you, whether they're an attorney or not, as long as they don't have a conflict of interest and can be disqualified. And then there's the discovery process. That is the right to request documents, ask questions in the form of written interrogatories, take depositions of witnesses. In many respects, the board tracks what your rights would be in U.S. District Court, but in a much more expeditious and employee pro se litigant friendly environment. And things are expedited. So the discovery process is a bit less than the discovery you could get in federal court, but nonetheless, it allows an employee to get access to all of the information they need to litigate the case, and the judges have a lot of discretion in the area of discovery. Next slide, please. Now, in a normal case, with the exception of cases like a whistleblower protection claim, which we're not going to get into in any detail, the agency has the burden of proof. But we've all heard the adage in criminal law that, you're innocent until proven guilty. And indeed, before the MSPB, the employee is innocent of the allegations against them until the agency meets its burden of proof. Unlike a criminal case, though, where the burden is beyond a reasonable doubt, the burden of proof before the board is a preponderance of the evidence, which means that more than half of the evidence has to favor the agency in order for the agency to win. If the agency fails to meet that burden, then the employee will win their case on the merits. The board has to have jurisdiction, though, and the board's jurisdictional rules can be complicated. But the employee has the burden of proving that the board has the authority to hear the case. The judge will tell you if they don't think the board has jurisdiction and issue you an order to establish jurisdiction. The employee can also raise allegations of harmful error, that agency procedures weren't followed, that due process was not met, and the appellant can allege that the action was based on illegal discrimination or retaliation. Those are called affirmative defenses. Next slide, please. There's also a requirement that the disciplinary action taken be connected to the job. They call that nexus, N-E-X-U-S. And those cases tend to become an issue. That tends to become an issue when an agency attempts to take an action based on off-duty misconduct, such as, for example, an employee who is convicted of shoplifting. There would be an open question whether that off-duty shoplifting is related to the employee's job, and that issue would be resolved on a case-by-case basis, depending upon the level of trust required by the position, whether or not the alleged off-duty misconduct related to the responsibilities of the employee on the job, and that's called a nexus determination. But if the agency can show that the alleged off-duty misconduct is connected to the job, it can discipline an employee for it. Next slide, please. In a disciplinary action, the board will also review the penalty. This is called mitigation. And many of you may have heard of the Douglas factors. There are 12 of them. Those are the specific factors that the judge and the board will consider in determining if the penalty is too harsh or whether the penalty is reasonable. There's 12 of them. I'm not going to go into all of them, but they concern things like the seriousness of the alleged misconduct, whether the employee has a prior disciplinary record, whether other employees were treated more leniently for the same offense, the individual's potential for rehabilitation. And an employee is not really limited to the 12 Douglas factors. They can present anything relevant to the question of their potential for rehabilitation and whether the penalty was fair. But the Douglas factors are the 12 specific factors that an administrative judge is required to take a look at. Next slide, please. Now, many of you are interested in the board and are here today because of RIF appeals. RIF appeals are different from appeals of disciplinary actions. Yes, the agency still has the burden of proof, but the board does not have the authority to reduce a RIF appeal of a removal to another action based on any type of Douglas factors or evidence in extenuation or mitigation. RIF appeals I would describe as a by-the-numbers process. There is a very complicated, very detailed RIF regulation And essentially, the board's role is to review the action taken against a specific employee and determine whether the regulations were followed. And the regulations are complicated, so we're not going to get into them with any specifics today. But they essentially concern 4 factors which determine who gets to keep their jobs and where an individual stands on what is called the retention register, which is a list of where you stand in relation to other employees in connection with these 4 factors. Now, there's been discussion in the media about the Trump administration wanting to change those 4 factors and increase the weight of some of them, such as performance, and reduce the weight given to others, such as tenure. But if any of you have already been RIF, the rules cannot be changed now. The existing RIF regulations would still apply to you. So the discussion in the media about changing the RIF regulations would only concern people in the future who would be subject to a RIF and how their appeals would be adjudicated. There's also been discussion about taking some of these appeals away from the MSPB and having them be heard by OPM. And obviously, as a retired MSPB judge, I would not want to see that happen, because the board, you see, is an independent agency that doesn't have a dog in the fight. The board judges independently review what happened against the regulation. And there's an argument that if you take that authority away from the board and give it to OPM, that there's a greater danger that agency actions would be rubber stamped. But essentially what happens in a RIF is these 4 factors are evaluated. Veterans get a higher status over non-veterans on the retention register. Disabled veterans get a higher position on the register than non-disabled veterans. Employees with more tenure who've completed their probationary period are in a higher position than probationary employees. Employees with more federal service are higher on the register than those with less. And your standing on the retention register is adjusted up or down based upon your recent performance evaluations. And it's a complicated process. We're not going to get into the specifics, but that's how it works. Now, what the board will then review is, did the agency have a legitimate reason to take the action? Was the RIF taken in accordance with the RIF regulations? And was the competition defined correctly? Everyone is either in a competitive area or a competitive level, and that determines how people compete against one another on the retention register. Next slide, please. The process for an appeal is straightforward. You file the appeal. Then the discovery process I've talked to takes place. Then the hearing. Now, no one's required to have a hearing. An employee can waive their hearing, and then the case will be determined on the record. Then there is a decision that will be issued by the administrative judge. That's called the initial decision. And that decision can be reviewed by the full board, which is where Ray Limon worked as a board member, which is analogous, like I said earlier, to an appellate court. From there, appeals can be further filed to the U.S. Court of Appeals, usually to the Federal Circuit. Sometimes in whistleblower cases, which we've not really talked about, they can go to one of the numbered federal courts of appeals. Next slide, please. One of the things the board looks for is whether there was a prohibited personnel practice. That's a list of what agencies are forbidden to do. And the board can reverse an action in many instances if it's shown that a prohibited personnel practice occurred in connection with the action. They would include discrimination based on race, sex, age, just like an EEO complaint, retaliation for whistleblowing, protected rights like being in a union, etc. When an action's taken for partisan political considerations, and so forth. Next slide, please. And now that I will pass things off to Ray, and I realize I went through this very briefly, but we'll have plenty of time for questions.
Great. Thank you so much, Rich. I appreciate that. Again, very useful. It kind of goes into a little bit about, again, why the board is so important. And before I get into some of the legal cases and issues that the board and frankly, what our country is facing, I wanted to also let you know on my background that I started my federal career as an OPM litigator back in the 1990s. And so I have a kind of a very deep appreciation of what OPM does, what the board does, and frankly, what we all do as civil servants. And I think being a civil servant and why you're on this call today is to expand your knowledge and your understanding about what it is to be a civil servant and what is the story behind it. Why have we moved away from the spoil systems? What was Congress thinking about to address those concerns? And of course, the predicament where we find ourselves now. It's very important. And whether you're a current federal employee or a former federal employee, you are all public servants. Your oath of office is something that you took, and it is something that you take with you for your entire life. So that requires a level of civic engagement, understanding of everything that's going on that either involved your agency's mission or just a broader aspect of what working in the federal government is like. So again, I want to thank you for your service and thank the partnership for putting forth this resource, and look forward to discussing some, again, the legal issues. You do not have to be a lawyer, I think, to understand all these legal issues, but it's important to follow them and be aware of them and understand that now how this impacts not only yourself, but your agency's mission as well, and then call into question, what do we want the civil service to look like in the future, right? So thank you for this. This slide kind of indicates a little bit about what the role of the board is. Rich got into a lot of that already, but it's primarily a body that adjudicates appeals. It came from the Civil Service Reform Act of 1978, when the last time we had a constitutional crisis, as far as a unitarian president, in this case, Richard Nixon, weaponizing many parts of the federal government to go after his political enemies. And Congress, through a very bipartisan support, nearly unanimous in both houses, the Senate and the House, voted to approve the Civil Service Reform Act. And it was a grand bargain in many ways. Prior to then, there was uncertainty and not clarity on how to hold employees accountable, how to fire them. So, there was a lot of managers who were really big on, yes, we need to do that. But also the unions and good government groups were saying, well, how do we balance that? Well, we balanced that by creating independent agencies, and we created separation of powers. So that law created the Office of Personnel Management to manage administrative, executive functions, policy setting matters. And then it created the Merit Systems Protection Board, an independent body to bring trust and accountability and eliminate political favoritism or retaliation by having a place for employees to go to have a fair hearing on whether or not the agency is following the law. So in this slide, it shows about, again, the vast majority of the role that the board does adjudicate appeals. Rich and administrative judges would typically hear about 6,000 to 7,000 cases a year. and up through the appellate process to reaching the board level was about 1,000. So that kind of gives you an idea about the number of cases historically, so since 2000 to 2024, yeah, there are about maybe 130,000 opinions rendered by judges. And then, also during that time period, appeals would come up to the board. We also, of course, had a significant lack of quorum for about a 5-year period between 2017 and 2022. Again, caught up in the first Trump administration in which board members were not being appointed. And so many of those cases, after an administrative judge rendered a decision, it simply sat in some boxes until the board was reconstituted. And that's where, I came in March of 2022. After getting through the Senate confirmation process, I had been a career employee for over 27 years. Again, working at OPM, being a chief human capital officer at a couple of agencies, and then getting a phone call to see if I would be interested in joining the board to get it reconstituted and start hearing those appeals. So again, it was an independent process. Board members could only be removed for cause as set out by the statute in 1978. And then all these cases that we would hear are absolutely reviewable by an Article 3 court or a court of appeals for the federal circuit in this case. So again, the idea about independence, the authority of the board to adjudicate cases is going to come into discussion as we move forward. So I wanted to pause and give you that background, and also kind of give you an idea where this all started. So I'm going to go ahead and go off screen, but can't we go to the next slide, please? Great. So this is the removal of Kathy Harris, my colleague, when I was on the board back in 2025, when the president sent a one-line email saying, in essence, your services are no longer required. You need to move on. Well, as a board member, she had the ability to stay on the board until 2028 before she got fired. And in my case, I was still on the board. My term was ending in March of 2025. I had just completed 30 years of service. So rather than pressing the cause of whether or not I should be extended, I decided to go ahead and retire so I could lend my voice to not only on behalf of Kathy, but also for all civil servants on reminding the courts and the public writ large on how important an independent merit-based civil service is. So that's an honor and a privilege for me to be in this advocacy work that I'm doing right now. But then, sure enough, the lower courts, like we've seen in many court cases involving the civil service, found that the president violated the law and reinstated Kathy. So she was on the board, came back to the board. So we had a quorum. We had 2 members, Kathy and the Republican member were still on the board. And then the government appealed that, went to the Court of Appeals, and the Court of Appeals said, no, the lower court got it right. So Kathy stays in her job. And she was in her job until the Supreme Court, again, on appeal. And again, this is part of that shadow docket that many people have been hearing about before the Supreme Court can hear the case on the merits. It decided that the MSPB exercises considerable executive control, and therefore Kathy should be removed pending the full case on the merits. So the DC Court of Appeals did also hear Kathy's case on the merits, and the Court of Appeals or DC Circuit panel did agree with the Supreme Court and said, yep, it exercises substantial executive power, and then went ahead and kept her off the board. So the board did not have a quorum up until, I think it was October of 2025, when another Republican member was appointed through a Senate resolution vote. So that person did not necessarily have a hearing directly, but was put together with a number of other individuals who were passed through the Senate on the Senate confirmation. So where we are today is Kathy did go to the Supreme Court and says, well, let's hear, I'd like to have my case heard directly, not combined with another case which had come up the ranks called Wilcox v. Trump. And so she's going to argue that I should have my case adjudicated based just on my role as being part of the MSPB, and that it is adjudicative, and that the Supreme Court should reverse. So I wrote, along with a couple other former board members, board employees, to encourage the court to take the case, and so it could then move forward and hear the case on the merits. So can we go to the next slide? And I just wanted to kind of highlight again what a kind of unique situation I think the Supreme Court is in when it talks about, the board being an executive authority and power, and not adjudicative. Because it's interesting, recently the Supreme Court heard a case, Lisa Cook versus the Federal Reserve. And the Federal Reserve governor was being also removed by the president without cause. It's a similar construct to other independent agencies like the Merit Systems Protection Board. But in this case, the Federal Reserve is absolutely responsible for doing executive actions. And yet it does no adjudication, but it did say that this person should only be removed for cause. So I think there's something very, if you will, hypocritical going on right now with the Supreme Court. That's why it's important to follow what the Supreme Court is doing, as it has that cascading effect with the Merit Systems Protection Board and a host of other executive branch agencies, with the Trump v. Slaughter, for instance, and the Federal Trade Commission, whether or not it's going to overrule a Supreme Court precedent that's been around for over 80 years, and Humphrey Executor, which again was a bargain that the Congress put in place to ensure that these agencies are independent, that those commission members can only be removed for cause. And of course, the president is taking a different position. And as of now, the Supreme Court seems to be supporting that position, except when it comes to the Federal Reserve. Can we go to the next slide, please? Okay, so this is the Jackler versus Department of Justice. This is a case that it was actually issued by the board. And I think what it does, it kind of shows the constraint that I just kind of talked about as far as why this is problematic for whether or not the board is going to remain to be independent. So in Jackler, these are career immigration judges, and they received a letter one day, saying that they are being removed under Article 2, and there's no protections under the Civil Service Reform Act, and so therefore you are no longer a federal employee. And so the immigration judges went to the MSPB, and Chief Judge Cassidy, in this case, looked at it and said, well, these are employees. They are defined as employees under Title V. Because you failed to give them due process, these cases must be reversed. And so I believe in, had I been on the board, I would have likely upheld that because that is, you know, classic federal law that employees are entitled to due process. However, when the Department of Justice, in this case, appealed to the full board, the new two-member board said, you know, they disagreed. They said that there is no jurisdiction, that even though these are employees under Title V, they are inferior officers and therefore can be removed by the president at will. And this is the first time that legal theory has ever been put into place. And similarly, within the Department of Justice, there's another office, Office of Legal Counsel. Office of Legal Counsel is kind of like a separate and special office within the Department of Justice that handles very complicated, nuanced legal issues. And it writes memos, and sometimes when an agency has a question of law, what a statute means, for example, or sometimes when federal agencies disagree among themselves, OLC will write an opinion, and it is binding on those agencies that says, "Yep, this is the legal interpretation for the federal government. Agencies, you must follow that." But again, the Merit Systems Protection Board is independent, so it does not have to follow OLC memorandum. And so, nonetheless, that memo was part of the record. And when the board, in this case, they said, "Well, we're not going to necessarily rely on it." But it was interesting, the rationale for overturning the administrative judge's decision was based primarily on the framework that was put forward on the OLC memo. So that really then calls into question the board's independence, and similarly, whether or not those judges would they also follow the same fate of Kathy if they had actually upheld the administrative judges and went against the administration, would they in fact have been removed? So again, I do believe that there are grounds for the Federal Circuit to reverse. So those immigration judges did appeal to the Federal Circuit, and the Federal Circuit will be issuing a decision. Don't know when, but it's certainly a case you want to keep a close eye on. So can we go to the next slide, please? So why should you care about immigration judges if you're not one? Well, because again, it's the methodology that the board used. Evaluating these Article 2 arguments, meaning the president's power to do pretty much whatever he wants. And in this case, there are other federal employees that could face the same fate. Whether or not they are administrative law judges, they could also be said, well, they're inferior officers, and they could be removed at will. What is the role of OLC? Is the board now going to be relying on kind of Department of Justice's guidance in all of its legal determinations, therefore making it binding on the board? There are many other adjudicators in many federal agencies that also, provide due process, not only for federal employees, but also for the public as well. Will they face the same fate? And then, of course, the Federal Circuit is expected to rule on, the Jackler case, and we also have to keep a close eye on the Supreme Court as well. And so these things are all happening, running in parallel, not only to what the courts are doing, but we got to also keep a close eye on how this impacts not only judges and employees, but also what's going on at the Office of Personnel Management. Can we go to the next slide, please? Okay. Oh, one more thing too. Yes, I forgot about this one. Our Article 2 removals. Okay, again, so I talked a little bit about what's going on with those immigration judges, but we've also seen a couple recent cases involving career Department of Justice attorneys. So one is Comey versus United States, and this is, yes, this is the daughter of James Comey, the former FBI director. She was also a career prosecutor, and she also received a letter saying under Article 2, your services are no longer needed. And so she went to federal court, and uh, and also there's another person, Coleman, same thing. And so what happened there is rather than going to the board, which sometimes you see federal courts doing, saying, well, you should really go to the board first, and then come to the courts. Well, here the judge said, well, because you are claiming that the Civil Service Reform Act is not applicable, then there's really no other court for you to go to than the federal court. So that is the proper forum. So prior to this judge's decision, the government stance was trying to have it both ways, right? They're saying, well, you can't go to federal court, you got to go to the MSPB first. But then if you go to the MSPB, you don't have jurisdiction. So we're finally seeing, again, the lower courts pushing back on this administration and the legal theories that they're trying to push forward. Okay, let's go to the next slide, because I think this is the one where I wanted to highlight, because a lot of federal employees are kind of dealing with these issues right now. So this is, again, OPM's attempt. So you talked about, the court cases, Article 3, cases going before the board, but this is running parallel to also stripping away additional appeal rights from employees. So there's been a series of rulemakings that OPM has been going through, and I kind of find it somewhat sad that I used to be one of the attorneys that used to review all the rulemaking to make sure that they do not violate merit system principles, that they're consistent with statute and procedures. And yet I see these litany of new rulemakings that are coming out of OPM that I think I would have been hard pressed back in certainly in the 1990s when I was working at OPM in approving any of these actions. But with that said, here we are. So they did issue a rule that eliminated MSPB review or probationary employees. That is final, and that is out. You've heard a lot about the schedule, policy, and career. That will also push employees through a classification process that once they get put into that classification, they will have no appeal rights. And in fact, when I was at the board, we did issue a reg that said that you had an opportunity to challenge that designation into that rule. And we could hear a case in a limited way to see whether or not your agency properly followed the rules in order to put you into that classification. Well, OPM eliminated that that regulation, and similarly, the board went ahead and eliminated that regulation as well. And I will say the board did it without notice and comment as well. Also, a concern are the suitability appeal regulations that are now going through, final publication with OPM. This is kind of a big deal. I think, suitability appeals happen normally at the beginning of one's career to see whether or not they are suitable for federal employment. Now, if an agency finds somebody unsuitable, rather than going to the board to appeal, basically you just have to go to, you could appeal to OPM, but there's no hearing. There's only a written record. OPM decides whether or not you're suitable, and there's no higher court review. So that's a particular concern, especially now that we have Trusted Workforce 2.0 and continuous vetting of our employees. And if something were to come up on that vetting, as well as the new broader definition of what suitability means. That could be a much streamlined approach for agencies to fire people without much responsibility to ensure that they're following the correct rules. Similarly, we've seen with the RIF appeals, stripping away appeal rights back to the board. Rich touched upon that a little bit as well. So every rule follows the same structure. OPM is stripping MSPB jurisdiction. They're creating an internal process to do that. And this goes exactly counter to what Congress created when it created the Civil Service Reform Act. So this is very concerning to me as a former OPM attorney, and certainly, working at the board. Can we go to the next slide? So again, what are some of the practical impacts of these OPM changes? Well, you lose a neutral adjudicator, someone who doesn't work for the agency that fired you. You lose the right to a hearing with live testimony. You lose discovery. You lose federal court review. OPM would be simultaneously writing the rules and judging your case under those rules. Again, this is completely an aberration to what Congress created, what the legislative process went through. And it's all being done through now either executive orders or through OPM regulations. And Congress hasn't done anything to change those laws. So again, this is very troubling. So given everything that I described, what should you do right now? And next slide, please. Check that if you are being terminated, check that language very carefully on what authorities the agency are using. That could guide some of your next steps. MSPB AJ decisions are still very valuable. The board wants to be, I think it should be independent. Some of that is being called into question today. But nonetheless, there is a process to have an AJ impartially rule on your case, and then there's always a chance to go to the federal circuit if you need to. Even if you're pro se, there are many appellants are pro se, so you don't have to have a lawyer per se. You can file a case. Right now, there's no charge to file an appeal. However, in the last budget resolution, I believe that Congress is now ordering the board to charge $350 to file an appeal. However, the board has not issued regulations to implement that, but that is something to keep an eye on. And also, keep all your agency's HR policies. If they made changes at the last minute under this new administration to comport with some of its procedures it's doing right now, you want to have a copy of what was in place before this administration, what came in after this administration, and to kind of see, did the agency follow the correct internal policies and procedures when it created those new HR policies. Those are all discoverable actions that you can ask for at a hearing or even under a FOIA. So you always want to kind of keep track. Agencies are required as well to follow their own internal policies. And I'm going to kind of finish up, come back on camera as we kind of come to near the top of the hour and get some questions. But if we could go to the next slide. And some of my contact information, I mentioned earlier that there's a litigation tracker of these cases that I've highlighted. In this case, you can also find on my website, meritserviceadvocates.com, and can certainly also reach out to me with questions either at that website or on my LinkedIn page. And Rich also has some contact information he could share.
Fantastic. Thank you both so much. Really, so much content. I know not a lot of time, so thank you everyone for sticking with us. That was really, really interesting. Now we have several questions that have come through already, and I can kick us off, and then both of you, I think you can see some of them that are in here, but what options are available to someone if they believe that their due process rights are being violated? Are there currently options available to remedy a violation?
Well, if you're appealing to the board, you need to raise the claim that the action taken was in violation of your due process rights, because the board can review whether the action was taken in accordance with law, and due process is a law of constitutional dimension. So you need to raise it.
And I would just also add, you still have other avenues, whether it's your Office of Inspector General, the Office of Special Counsel is also a place to file whistleblowing or other actions involving prohibited personnel practices. But that agency too is also a concern where the president fired that independent agency head as well. And so whether or not that agency remains to be independent is also, I believe, a concern out there.
Great. Another question, do employees have a right to see the retention register?
They can request it in discovery. Yes, so absolutely they do. But I have to say, most of the RIFs taken by the Trump administration, like against USAID, it's not so the outcome is not going to be determined largely on the retention register, because so many people were RIFed. It was a massive RIF. You know, those RIFs are probably going to turn on whether there was a legitimate management reason for the taking of the action. But yes, absolutely, the retention register normally would be part of the agency file. But if it isn't in the agency file that the employee receives, they can request it in discovery.
And I think that's important too for our listeners here, in that if they filed a case or about to file a case, there's been a huge tranche of cases, USAID, HHS, and others that have currently been getting through the discovery process. And at some point, the administrative judges are going to have to rule on whether or not these RIFs were legal or not. And that's where I think these litigation trackers are going to be important, because it's something I'm keeping a close eye on. And that could then change if you're later in the queue and your cases haven't matured or matriculated up that far. You could have a chance to amend your complaint, amend your appeal, and then also impact the way you do your discovery, depending on how these other cases are matriculating through the board.
Thank you. And this next one, I would wager, applies to many folks on the line. How do RIF regulations and MSPB process apply in the case of an organization that's been eliminated in its entirety, such as USAID? So for folks that are maybe affiliated with an agency that's conditions have changed since they were RIFed.
Well, those cases are going to turn largely on the legal question of whether the administration had the authority to take that action, because often many of these actions allegedly violated, among other things, the Impoundment Act, because funds were appropriated by Congress for the agency, and the White House ignored that and unilaterally acted. And the main thing for someone who is a pro se litigant to know is you need to raise the issue. It can be as simple as saying that, the agency action was not lawful because the monies were appropriated by Congress and the agency existed by act of Congress. And then the heavy lifting of the legal briefing and so forth will probably be done by others. And then you can benefit from that by having raised the issue. I noticed in looking ahead at the questions, one of the other questioner asked about the delays in the process. Often the judges, for case management reasons, will not rule on something if they know that a decision on one of the relevant legal issues is pending elsewhere. because why make a ruling and then end up being reversed because the board does something else? It makes more sense to hold that case until you have a ruling from the board or the Court of Appeals that's going to be outcome dispositive. So that will often explain what appears to be a lengthy delay.
And I'll also add, as far as like, what Rich was talking about the RIP, I think that's right. The most, I think, litigious part of this is whether or not there was a bona fide reason for that RIF, or maybe in this case, an agency shutdown. And we saw recently in a district court a case here in DC, I believe it was Judge Royce Lamberth, found that when Carrie Lake was running the restructuring at Voice of America, she was improperly appointed, and therefore in the actions that she did were invalid. So that's also something that many agencies should be looking at on determining who in fact authorized the RIF, and that could sometimes have to wait till discovery, and then whether or not was that person properly appointed to do that RIF. Now, whether or not that the board will look into that and determine by law if that was a legal action, that's still, of course, TBD, but at least we know at the federal court level that decision has been looked at, and that may influence cases down the road as well.
A question that I think ties on to what you were just sharing, what happens for someone that was maybe riffed or involuntarily separated and is appealing to the MSPB, but are now employed by another part of the federal government, took another job in the federal government in the meantime?
Well, that really would affect the relief the employee would get if they won. And those are kind of complicated rules. And, the employee would be at a minimum entitled to back pay and could seek reinstatement to their previous position. Or they could simply say, I want to stay in my new position, but I want the back pay I'm entitled to, which would be reduced by the subsequent earnings. But still, there may be an entitlement to back pay and, if appropriate, attorney fees.
I'm going to pause you both for just a minute as we're almost at time. And if you want to think about any last questions that we can get to in the last few minutes, I do just want to pause and ask that folks take a look at your screens. We're going to pop up a very quick poll that just has 4 very short questions regarding your experience this evening and offers an opportunity for you to share a few more ideas that you might have about questions that maybe didn't get to tonight, or other topics that you'd like to have a webinar on in the future. So please feel free to fill that out. We really appreciate your feedback and really try to create sessions that work and solve the problems that our audience is looking to have more information on. So I'll hand it back to you both. Are there any other questions that feel like there's an answer that might be useful for this crowd at the moment? I'm sure there's a lot.
Well, one question was, do the RIF appeals rules apply retroactively? The agency cannot change the rules. The prospective changes that Ray talked about in terms of what the Trump administration want to do, they are prospective rather than retroactive. Another question was, and I assume this involves the mass termination of probationers, where the question is, if the agency says that the basis for removal was inadequate performance, but the employee's recent performance ratings were excellent, how would the board review that? If that's in the context of probationary cases, that's a complicated issue because normally such cases would be outside of the board's jurisdiction. And I really couldn't even venture an opinion on that. But if you're talking about a RIF and the person's standing in the retention register was lower than it should be because their performance wasn't correctly calculated, that is something that the AJ can specifically review. And if an employee is removed for poor performance, the agency is required to prove that as part of its burden of proof.
All right, I know that we are just about at 7 o'clock, and I know that it's important to hold to time, but you may have other questions for our panelists. So they've both very generously shared their LinkedIns. They're in the chat, so you can feel free to reach out. And also, Ray has a fantastic tracker that we'll drop in the chat that can help you stay up to date on everything going on. But again, a big thank you to both of our fantastic panelists tonight. This has been a very informative evening. And for those in attendance, please visit our FedSupport website for more resources. And this session recording, along with any past sessions that we've had, I know this is the second time that we've had Ray on, but FedSupport more generally acts as a hub or a front door to a range of resources, not only things that the Partnership for Public Service has developed, but also things that have been developed by many of our other partners, like those that you've heard from tonight. Like I said, we'll drop Ray's Merit Systems Monitor here, so you can stay up to date on everything going on, all things MSPB. And as you navigate your current situation, our hub offers a range of plain language explainers, help you understand what's going on, what your rights are, how to understand this really quickly moving environment to the best to your best ability. So we've got things on RIFs, pay and benefits, other personnel actions. So please feel free to check out our site and let us know if we can provide any resources that you're not seeing. We're always open to feedback, and hopefully you drop that in the poll that you saw. But Rich, Ray, thank you both for joining us this evening. We really appreciate it. And for all of the feds who joined us tonight, thank you for your service. Thanks, everyone. Have a great night.
Bye.
Thank you.